Bob, it's great to have you here at the Gene Editing 360 conference. Thanks for coming. In your experience, and certainly experience of your colleagues, have you ever heard of a situation or experienced a situation or time when such a remarkable biomedical technique, such as CRISPR, is engaging and engendering such enthusiasm throughout the legal community?
Yeah. Well, first, it's great to be here, Eric. And you're right that the CRISPR technology has garnered a lot of interest in the legal community, and I think that's a reflection of the breakthrough nature of the science. Rather than a biomedical technique, what I kind of relate the interest over CRISPR to is other breakthroughs in science, such as, for example, a few years ago, the advance in hepatitis C development, where you went from some treatments that did not work particularly well to a true cure. And I think the legal and the interest in the legal community is reflective of the breakthrough nature of CRISPR, like some of those other things.
Yeah, that's great. And from a unique perspective, and we're delighted you're here because you are deeply engaged in these sort of patent discussions. From where you sit, how do the filing of patents and patent process actually stimulate or engage innovation?
Yeah. Well, the policy of the patent system is to try to promote innovation by giving some incentive on the back end. If you develop something novel and new, you get a limited monopoly with which to practice that invention in exchange for disclosing your invention to the public. And I think that type of incentive is particularly important in the biotechnology industry, where you have such an upfront investment required to do this work. It's extremely complex. There'll be many failures. There'll be a few successes. And I think in order to keep companies and institutions incentivized to go down that road, the patent system is important to provide that back-end incentive.
At present, we're all watching legal proceedings and decisions relating to kind of the foundational patent of CRISPR between two groups we know of, possibly more throughout the world. But folks who are continuing working in this area and scientists developing improvements and alternative paths with CRISPR, are they going to have to be going through the same process, or will they be held sort of to the original foundational patents? And how does that kind of work?
Well, the patent system recognizes that much of science is built on the work of others. And so improved processes or methods of treatment or therapeutics developed using the CRISPR technology are subject to patent protection in their own right as their own inventions. The issue is whether those follow-on inventions practice the original intellectual property, that broader-based intellectual property. And it may or may not be the case in certain instances that the follow-on inventions will need a license or had to have rights to that earlier IP in order to practice their inventions. And I think it'll be very interesting. One of the things we're looking forward to seeing how all that plays out over both this dispute that you referred to and over the next couple of years.
Excellent. Bob, it's great to have you here.
Yeah.
Thanks for coming.
Thanks for having me,
Take
Eric.
care.